Morning, Council. Welcome to the First District Court of Appeals. First case this morning is Moore versus Colerain Township. Mr. Miller-Novak is here for the appellee and Mr. Solomon for the appellant. Mr. Solomon, would you like any rebuttal time this morning?
Yes, Your Honor. I'd like to reserve 4 minutes for rebuttal, please.
Okay, you may. Please go ahead and proceed when you're ready.
Okay. May it please the court. My name is Scott Solomon from Schroeder Mondrell, Barbarian Powers. I'm here on behalf of the appellants, Colerain Township, and the individually named respondents. The township has appealed the trial court's decision in this case with respect to the trial court partially denying the township's second motion for summary judgment and partially granting Realtor's amended motion for summary judgment with respect to Realtor's claim that the township's land use committee violated the Ohio Open Meetings Act. Specifically, the township maintains that it, as opposed to Realtors, is entitled to summary judgment because Realtors failed to proffer evidence at the summary judgment stage necessary to establish that a quorum ever existed with respect to any possible OMA violation as to the land use committee. Additionally, the township further maintains that the evidence establishes that the land use committee did not constitute a public body under revised code 121.22. Thus, no OMA violation was possible. As set forth in our brief, this court in the Cincinnati Enquirer versus Cincinnati Board of Education held that one of the elements necessary to establish an Open Meetings Act violation was to demonstrate that the public body conducted a meeting. The court held that the OMA defined a meeting as a—
And we've got this draft report that has this picture that is captioned as this land use committee at one of its meetings. So what's wrong with that?
Well, initially, I would say that the draft report, and I cite to a number of cases in the brief, it talks about what is proper evidence under Rule 56C, is not proper evidence. But even assuming the draft was actually properly considered by a trial court, which we contend it was not, because it was never properly authenticated. Even assuming that was considered by the court, even with respect to that picture, there's no identification or testimony as to who is inside the picture. If it's voting or non-voting members inside the picture, you need at least 4.
Well, but I guess, Mr. Solomon, I mean, they're your clients, right? So are you disputing that is a quorum based on who you know in that picture?
Honestly, I only know one of the people in that picture. I've never, because opposing counsel, I know that it includes General Account, a former zoning director, whose deposition was never taken. Quite frankly, the other people in that picture, I don't know. I assume Jesse Urbanski may have taken the picture. I don't know who the other people are. I haven't met many of these members of the land use committee because they were never deposed. There was never any reason for me to meet with them. I've emailed, I've corresponded with them, but I've never met them in person. I couldn't testify right now who those people are in that picture, let alone the trial court to know who those people are. So no, and I think that it might be a formality as far as establishing a necessary element, if you want to call it that. But I think that that's part of the deal as far as establishing that there was a violation. You have to show that there was a meeting.
Well, what about the emails, Mr. Solomon? What about the emails?
With respect to the emails, the case he relies on is, was it White versus King? And in that case, not only are there completely different facts at play, but there's also different standards. At one point, White versus King is the Supreme Court is considering a motion for judgment on the pleadings, as opposed to in this case, in that case, they have to assume every allegation is proper, and they don't consider really any of the evidence. In this case, it's at the summary judgment stage. We have the evidence before us, or in my opinion, the lack of evidence before us, that the burden is on the plaintiff. In the facts in White versus King, as was put in the amended complaint at that time by the plaintiff, involves a series of emails between 5 of 6 school board members, a superintendent, and additional district staff who were meeting for the purpose of drafting a response to an editorial that was subsequently ratified at a public meeting by those 5 school board members. That, in this case, we're talking about 2 emails, which comprise of a 4-sentence email initially on January 30th, 2019 at 1:34 p.m. and a second email sent approximately a day and a half later on February 1st, 2019 at 12:02 a.m. Neither of those emails really contains any evidence or reference to any decisions, recommendations, or even really any purpose of the emails. And even
Mr. Sullivan, weren't they discussing certain neighborhoods and talking about a particular type of business in a neighborhood and discussing the desirability or undesirability of those businesses in that neighborhood and what they wanted to do with it?
Well, I think however you could, I think they also talked about the fact that Colerain Avenue may have been a main vein in Colerain Township. Well, if you've ever been to Colerain Township, that's pretty much, it's not like, I don't know, I mean, is that discussing public business? I don't know. Regardless, the court knows that, in Cincinnati Post versus City of Cincinnati, the Supreme Court has held that the statute does not prohibit impromptu hallway meetings between council members. It's concerned about prearranged discussions.
Well, but I guess going back to the report, I mean, the report is, I realize it's called a draft report, but it is a weighty document that took a lot of time to put together, goes into very substantive details. And like, how could this committee have generated that report without meeting or communicating in such a manner as to solicit input from everybody?
Well, I think the report, as was testified by former planner, Mr. Urbancic, it was created by general account. It wasn't created by, there's no evidence to show that it was created by any of the other board, the committee.
Did she just like go rogue and draft this report? In our, there's a lot of cut and paste with respect to zoning directors. And I understand there's nuances, but whether those were hers or, if you want to go by the bylaws that guided this committee, it required written recommendations that ultimately were submitted to the zoning director after a formal vote was taken. The evidence shows not only was there never any roll call, there was never any vote ever taken. There were never any written recommendations that were ever provided to Mrs. LeCount. So I don't know if she came up with this on her own, if she, she was never deposed. Regardless, there's no evidence to show that they made these decisions and or had any input into what was created ultimately as a draft. And Ms. LeCount is a former planning and zoning director. She is not the board of trustees. She's not even the administrator. Someone who is on the higher up, who, in my opinion, obviously can represent the township. So it'd be different if it was a draft meeting minutes that were ultimately ratified at a subsequent meeting. The board of trustees never ever saw this document. The administrators, no evidence that anyone besides general account, and the emails that occurred, ever saw this account, this draft.
Mr. Solomon,
sorry, go ahead, Judge Winston.
You go, Mr. Solomon. It's my understanding that Colerain Township provided the draft. Wouldn't that be an admission against interest if your clients produced it?
I would say that in producing it, we produce all kinds of documents with respect to public records and in other discovery, right? I think that even regardless of the fact that you produce, you still have to authenticate it. Just because you produce something, there still needs to be testimony that goes to that.
Let me ask you, I don't mean to interrupt you, but didn't Mr. Urbancic identify that in his deposition, the draft report?
Well, if you want to go ahead and he talked about the fact that general account did 100% of the text, and depending on what do you want to consider an omission for what purpose, I guess is my question to you, Your Honor. If you're trying to say that the picture without the caption, that's okay, fine. I mean, because he testified, he did the pictures and the digital, all the other digital stuff. He had nothing to do with the actual text, including the caption. that would have been underneath that picture, which in my mind is really what, the realtors hang their hat on in establishing quorum. And with respect to the other part of my argument is the fact that the land use committee doesn't even constitute a public body under 121.22, because a proper reading of 121.22B1 details that a public body is defined under 121.22 is required to be a decision-making body. Just because a public body such as the Board of Trustees created it, it doesn't mean that the committee is.
So to make sure I understand your position, that if a public body, say Cincinnati City Council, creates a committee to advise it and make recommendations to it, that committee does not qualify as a public entity because it doesn't have actual decision-making authority.
No, I think there's case law out there to talk in the City of Cincinnati, Enquirer versus City of Cincinnati. I think there is just because they were advising the administrator and the board directly. They considered them to be a decision-making body because it made decisions and directly. The key is here directly advise the City of Cincinnati Council. In this case, there was no interaction between the trustees, the administrator of the township. It was just the zoning director who they were advising. That was the purpose of the actual committee, was to advise.
Mr. Solomon, wasn't they went to all the trouble of preparing that draft report? It was my understanding that it was going to be submitted to the trustees for either approval, rejection, or something or other. But I thought it was the intent of the committee to submit it to the Board of Trustees.
I think you're right. I think at one point it was probably the intent, but did that happen? No, the evidence doesn't show that. And I would say that just because there has to be some direct advising or decision-making that occurs. And in this case, there's no evidence to support that. Whether they may have, and you keep saying they, I contend that the only evidence in this on the record is that Jesse Obrancic said that Jenna LeCount had 100% of the text. There's no evidence on the record to show that, hey, she received any written recommendations or even considered any actual testimony or discussion that occurred at a meeting where we don't know how many people were at. If there were 4 people there.
Mr. Solomon, you are at your time if you'd still like to reserve 4 minutes.
Thank you, Your Honor.
Okay, thank you. Mr. Miller Novak. And you're muted.
I promised myself I wouldn't do that. My name is Matt Miller Novak. May it please the court. I'm here on behalf of the relators, Kathy Moore and Stephanie Wright. Your honors, I think this case, there is a clear public body that met privately and did a lot of policy recommendations, which is decision making. So we have a public body. And I don't think the case law is unclear about that. I don't think the facts are unclear about that. And because of that fact, I think that the appellees are pulling off some interesting mental gymnastics to, at times, invent evidence rules that don't exist, to contradict the ones that do exist, and to also contradict the case law that is on point regarding this public body. The one thing I want to point out, and I think before I talk about evidence, I actually want to talk about the case law regarding public bodies and policy making and making recommendations, decision making. But I do want to point out that in the appellee's brief, the standard of review that they present actually is inappropriate regarding reviewing decisions on evidence in a trial court. They present the standard review as a de novo standard for everything, where we do have 2 issues here, one of them being substantive, which is whether or not it's a public body, which is de novo, and the other issue is whether or not certain evidence was admissible, which is supposed to be reviewed under abuse of discretion standard. But let me get into the substance of the case before I address.
Well, let me ask you this question, because there's been a lot made about the evidence as to whether a quorum actually met. And, as I read through the deposition transcripts, I never saw like the exact question was there a quorum at these meetings? And like, I don't understand why that question wasn't asked, but without an answer to that question, what is your best evidence to establish a quorum at these meetings?
Right, Your Honor. There's a photograph, and the photograph shows it shows 7 members.
Well, but I guess, so on the photograph, I mean, to tie into my earlier question, like, I don't know who those people are. Is there some testimony in the record that walks around the photograph and says, this is Mr. Smith, this is Ms. Jones, et cetera?
No, Your Honor, but on page 91 of Jesse Urbanzic's deposition, I do ask about what's depicted in the photograph, and I ask if it shows the committee doing their work. And he said yes, Your Honor. He actually said yes. He didn't say, no, that's only part of the committee and things like that. So it didn't really occur to me that I would need to actually make him identify each individual person, because number one, the caption expressly states that it's the committee. It doesn't say part of the committee. It doesn't say any less. The amount of people in there are 7 people. I asked Mr. Urbanzic, does this photograph, what does it show? And we did have a brief discussion that it showed the members of the committee pointing at maps, doing things, doing their work. It just, honestly, Your Honor, I think it's one of those issues where I think their argument about a quorum becomes a little lacking in being genuine, in the sense that it would have been so simple for them to say in any affidavit. I wouldn't even have expected the argument, because in any affidavit, any deposition, they could easily said, we never actually met as a committee. We never had a quorum. We never did a meeting. Quite frankly, I think if you look at the record overall and all the arguments, it's almost somewhat a non-contested issue that the committee did meet. The committee did do work. It wasn't really brought forward that that was even a challenge to the case until summary judgment, because the photograph showed it. There's emails where they're actually reviewing their work. I think when we talk about this,
are there emails where the draft report is being circulated and discussed?
Oh, yes, Your Honor. And that's one thing that is, I think I do allude to that in the brief, but maybe not as a great detail. There is one point, and I think that's really problematic, when they're suggesting that Urbanzic cannot authenticate the document because he didn't write the words. That's actually not true. He's the one that finished the report, because there's an email chain that's in the record where the entire committee is actually circulating the final rough draft and actually making edits to it. So they're editing in terms of grammar, they're editing in terms of the presentation. So after LeCount was gone, it was actually Jesse Urbanzic that finished the writing with the entire committee in an entire email chain. And if you look at the summary judgment drafting, as well as my oral argument, you will see that that was discussed. The appellee's defense was, well, that doesn't count as deliberation because it's just grammatical, but it does show the entire committee reviewing their work, making last minute edits to it, and then saying, hey, this is the final draft. So to continue, Your Honors, when it comes to whether or not the committee is a public body, I would point you to Cincinnati Inquirer versus the city of Cincinnati. And there you have an urban design review board that was actually comprised of architects who were not government officials. And that committee was created by a city council vote, number one, to inform the administrator on land use, which is exactly the case we have here. Here we have the trustees that create a resolution and they create a committee, they appoint its members, they pass its bylaws, and the entire purpose is for them to make recommendations that will be included in an administrative report that will come back to the trustees to vote on. So these are policy recommendations. And
so does the committee actually have to follow through on that for it to become a public entity, or just the mere fact of its creation establish that component of it from your perspective?
I think it's creation and it's act of making recommendations. The committee actually did follow through on their work, and that's the thing that's problematic, is the committee actually did make policy recommendations. We can see it in the draft land use plan. So there's one answer. I would say that they actually did their work because they made policy recommendations that were created in plan. And if you look at the record, the only reason the trustees didn't vote on it is because the township administrator instructed the township trustees to not vote on it because of this pending litigation. It was actually Trustee Raj that answered that question in a deposition, admitted that the reason they were not voting on it wasn't because they weren't going to vote on it or that the work wasn't done by the committee. It was because essentially we brought this action to enjoin this unlawful activity. I would also point the panel to the plain language of the statute itself under RC 121.22I. A relator doesn't have standing to just enjoin things that already happen. If you see, the plain language says that a relator has the standing to enjoy things that are threatened to be violations. So in other words, relators don't have to wait until a public body meets 25 times to privately deliberate and make its decisions to file an action in a court to enjoin it. When it's obvious that a public body is violating the Open Meetings Act and is going to make official decisions in violation of the act, relators have the standing to file for an injunction to enjoin that threatened violation of the act. And at the worst, that's what we've done here. But I think in reality, we've filed an action to enjoy things that already occur. Regarding, to get back a little bit here to Cincinnati Enquirer versus Cincinnati, the other issue there was that the Urban Design Review Board didn't report back to the city council in the manner that the appellees are suggesting it did. If you actually look at the facts, you will see that similar to here, essentially, what they were doing is that there is a background document on Urban Design Review Board that the secretary of the UDRB states that, and this is quoting right from the case, the board may review other projects as requested by the city manager or the city council. So it's not like there was evidence in Cincinnati Enquirer versus Cincinnati that they were coming to meetings and making formal presentations to the city council. It's just that, and their responsibilities, part of their duties were to potentially have to report back to city council. And I think,
so I guess, like, does that mean that anytime a public entity creates a committee that has some task where it may report back with some recommendations, that in and of itself constitutes, that means the committee is subject to the Open Meetings Act?
Absolutely, Your Honor. Actually, I would probably point you to another case that we cited, which was, sorry, I'm going to bring it up here. My notes got a little disheveled. So it's actually Weisfeld versus Akron Public School District. And in that case, and it was a 9th District Court of Appeals case from 1994. But in that case, what happened was that the school board created a public body through contract, because what it did was it entered into a contract, and part of this contract, the school said that the administration was charged with forming committees that would advise the administration on how to redevelop the schools. Those committees did not even report back to the school board at all. But that appellate court held that it was a public body because the public body was created by a formal action of the school board. So here we have a case where it was held to be a public body, where that public body didn't even have to report back or had no responsibility to report back to the public body at all, because the public body created that committee through a formal action. In this case, that's precisely what happens. But here, the public body, aka the Board of Trustees, creates this committee with the express duty, and I just want to read from their own bylaws that they created, that the members of the Comprehensive Plan Land Use Committee, quote, shall serve at the pleasure of the Board of Trustees. It continues that the function, organization, operation, existence, and membership of the Comprehensive Plan Land Use Committee may be changed at any time upon 2 votes of the Board of Trustees. So this isn't may. This is a committee that's entire existence is under the control of a majority vote of the Board of Trustees. And no more was that obvious than in the middle of this case, while the appellee was arguing that this wasn't a public body, it was an administrative body, the Board of Trustees voted to dissolve it. And then the appellee argued that that made the case moot. So essentially, you're talking about a public body that couldn't even dissolve itself. You're talking about something they're claiming to be administrative body. Well, if that was the case, then the township administrator would just say, we're done, folks. Pack your bags up and go home. But that's not what occurred. They had to go to the Board of Trustees to ask the Board of Trustees to dissolve itself. That just is not an administrative body in any stretch of the imagination. If it was administrative, the administration would choose its members. The administration would choose its purpose, and the administration would have the power to dissolve it without asking for any input from the Board of Trustees or without asking for their permission or vote. I do want to address the idea of evidence of a quorum at all, and I want to address this email chain that I think the appellee kind of just flatly ignores the actual substance of the conversations, because there we're looking at what's called a round robin discussion. That is not people coming across each other at a cooler. The whole entire conversation starts with Jesse Urbanzik basically saying, hey, good work, guys. Kind of like, let's talk about what we're doing. And then you have one of the committee members saying, hey, we need to think about this stuff. We need to think about us as a heart. We need to think about Colerain having arteries and veins. If the conversation stopped there, the appellee's argument would have merit, but it doesn't stop there. What you start to get is a deliberation, because you get a chain of ideas. You have another committee member saying, hey, I like your ideas. Let me give you more ideas. She gets into concepts of noise pollution and other things. This is a very deep conversation that is at the core of the substance of what the public body was charged to do. And it's an exchange of these ideas between these committee members. At no point in time does anybody say, hey, let's stop this conversation. We have a quorum here. We should do this publicly. They continued. And that's the issue here. And that's exactly.
Well, and Mr. Miller-Novak, you are at your time now.
Okay. If I could just finish up with saying that's exactly what the Supreme Court addressed in White in the case that we cite about round robin conversations through telecommunications such as email or text message.
Thank you. Mr. Solomon, you have 4 minutes for rebuttal.
Thank you, Your Honor. I would like to initially address one of the realtors talk about this picture, which they keep pointing to, and I think you asked, Your Honor, hey, is there any testimony as to this picture? And the realtor, Mr. Novak, stated that there was. They talked about this picture that contains, he counts 7. I don't count 7, but that is not actually the case. And I addressed that in my reply brief, where I talk about specifically, there was testimony as to the cover page of the actual draft use. And it talks about the only testimony by Mr. Urbanzik is that on page 91, and he says, okay, this is after he says that LeCount did 100% of the text. I did graphic design and mapping along with photography. Okay, so these photographs, you took parts of Colerain, looks like on the top, on this cover, maybe the third rectangle on top is this like a picture of the committee actually working and doing? And the picture they're actually talking about, if you look at, it's at the bottom of my page 5 of the reply brief, is just one of 8 pictures on the cover page that actually half of one person and then half of another. There's only 2 people who are in that committee. That's the only testimony that Mr. Urbancic talked about as far as any picture. With respect to, Mr. Novak talked about a few cases in regards to, I think specifically the Cincinnati Enquirer versus Cincinnati case. In that case, I'm reading, if you look at page 338 of it, the paragraph in that, according to the stipulated record, though, the UDRB, that urban design team, advises not just the city manager, but also the Cincinnati City Council, which clearly is a public body. Again, that never happened in this case. Hence, it's distinguishable. In the other case, Weisfeld versus Akron, they talk about, this is in the opening syllabus on page 456 of this case. In June 1991, the board approved a collective bargaining agreement that allowed individual schools to form BLTs, a form of site-based management. When a BLT is created, the teachers and principals share in the decision-making of the building level, at the building level. Again, decisions are being made by a CBA, a contract. There was no contract in place here. There were engineers that made up the UDRB and the Cincinnati Enquirer versus Cincinnati case. These are just residents. You know, they didn't have any specialty skills that they were retained by the city to utilize. You know, with respect to the distribution of the final draft, and I don't know how you can say when is the draft final, because it was never submitted. And who knows how far, you know, aside from a few, I will agree that it was maybe distributed to some of the committee members, but as far as them reviewing it, again, there's no evidence of that. I'll concede that with respect to the few who may have responded with a few typos here and there, nothing of any substance at all. Maybe those 2 at least reviewed the draft, I guess, in its final form, even though it was never submitted. But as far as that goes, again, there's no stipulation here that these people made any decisions or any recommendations directly to the public body itself. There has to be more.
What about his point that once they were on the cusp of doing that, you know, council advised them to shut it all down?
And I'm not saying that. I mean, typically that's not an atypical. When something happens, if there's litigation, you stop with, you know, don't do any. That's a normal kind of caution of counsel. If that was the case, you know, at some point, would they have ever finished it? How come now then they've gone completely a different way? Now LeCount was let go shortly prior to, you know, during this all happening, and I don't know if her job satisfaction, that was an issue, but the reality is now the land use element that's in place, that it has been approved since this litigation is going on, has nothing to do with this. It's all electronic because the township is trying to be as transparent as they can. It's all online now, and it has nothing to do with any of this land draft element at all. You know,
okay. All right, you're past your time. I gave you a little time to respond to my last question, but thank you for your argument. Thank you both, counsel, for your arguments this morning. Very interesting case. We'll take the matter under submission and get out a timely written opinion. So hope you both have a great day.
Thank you so much, Your Honor. Take care. Take care, Matt.
Thank you and goodbye.
Morning, counsel. Welcome to the First District Court of Appeals. We're here on the second case to be argued today, Freedom Fund versus, is it LVREIS, or is there a way that we should pronounce that?
Yes, Your Honor. It's Levrese, but it during the trial we did both, but it's a mouthful. So I just say Levrese.
Okay, that's easy enough. Thank you. Ms. McNamee, you have 15 minutes to argue. Would you like to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes.
Okay, you may. Please proceed when you're ready.
May it please the court. Good morning, Your Honors and Mr. Matre. I'm here on behalf of Appellant Levrese LLC. This is a quiet title action regarding the validity of a commercial promissory note and mortgage. Levrese is a mortgage lender that entered into a $90,000 promissory note and mortgage with the Appellee Freedom Fund LLC. The Levrese note and mortgage were signed by one of Freedom Fund's member managers, Jay Greenwald, and the mortgage is secured by a parcel of property in Hamilton County. The operating agreement for Freedom Fund states that it is a member-managed LLC. Although the trial court correctly recognized in its decision that Jay Greenwald is a current member of Freedom Fund, it concluded the note and mortgage are invalid because they were not also signed or approved via resolution by the other member of Freedom Fund, Loan Buddies LLC. We respectfully submit this decision was incorrect and should be reversed because the law and evidence reveal that Mr. Greenwald individually had the actual, apparent, and ratified authority to bind Freedom Fund to the Levrese note and mortgage.
So but what about the trial court's findings on effectively collusion between your client and Mr. Greenwald? Like, how does that implicate any authority that he may have had?
Well, there are 3 different flavors of authority, Your Honor, that we are arguing. One is actual, the other is apparent, and the third is ratified. Whether there was collusion, it has to do with whether there was apparent. And so if we get to that, then that.
So in other words, if he had actual authority, your position is it wouldn't matter even if there was some collusive aspect to this deal because he had actual authority under the operating agreement.
Exactly. But also, Your Honor, in that aspect of our argument, we basically said that there was no evidence of collusion, that was, there was no evidence cited in the decision. That was just a conclusion without any citation to evidence that was presented at trial. But beyond that, if he had the actual authority, then it wouldn't matter anyway. And the collusion was only if there was any. What the trial court said was that the money from the Freedom Fund loan did not go to Freedom Fund. It went to purchase property for another LLC that was owned in part by Jay Greenwald. As I mentioned in the briefs submitted by Levrese, I have thoroughly explained why we believe Mr. Greenwald had the actual, apparent, and ratified authority to bind Freedom Fund to the Levrese loan. This morning, however, I would like to focus my argument primarily or exclusively on the actual authority. But of course, I'm happy to answer any questions about apparent or ratified authority if this court has any questions about it. Why the trial court's decision regarding Jay Greenwald's actual authority is particularly important is because it's clearly inconsistent with LLC statutes, bar title standards, common practice, and precedential case law. The decision essentially creates an additional level of approval for loan documents executed by managing members of LLCs. If left unreversed, the decision could put into question the validity of many mortgages executed by LLC members under the express authorities of their operating agreements, simply due to the lack of an extraneous company resolution. The trial court incorrectly concluded that under both Ohio. I'm sorry.
Let me interrupt you. What language exactly in the operating agreements gave him actual authority to take out this loan and have the proceeds go to another LLC or another entity?
There in the operating agreement itself, and I've cited this express provisions in there in my brief, but it said that each of the members had the authority individually to act on behalf of the LLC. It also said that the individual members had the authority to represent to financial institutions their authority to act on behalf of the limited liability company.
Well, let me push back a little bit on that. Okay, far as the first part, actual authority to act on behalf of Freedom Fund.
Yes.
If the money was not benefiting Freedom Fund in any way, shape, or form, how is it acting on behalf of Freedom Fund?
It's not acting on behalf, it has the power to act for Freedom Fund, whether it's on behalf of Freedom Fund or not. In a member managed LLC, the individuals have the right and the power to bind the LLC. You don't need it. And I think what you're getting to is the trial court concluded that they were not operating for the benefit of the LLC when the money didn't go back to the LLC. But what is important isn't how the funds were used. Members take out equity of the from LLCs all the time.
Well, I think Judge Bach's question kind of implicates what I was trying to ask earlier, which is if surely, if the operating agreement says you can go do this, then that seems to create actual authority. But if what you're doing is not really just that for the benefit of the corporation, but you're stripping assets because you're diverting those proceeds to some other entity, like, does that change the nature of the actual authority? Because obviously the operating agreement does say you can go strip assets or something like that. I mean, that's the distinction I think we're both kind of looking at, and would appreciate any thoughts you have on that.
Well, I think that how funds are used, what's important from the perspective of authority is if you look at the operating agreement, a title company needs to make sure that any member of an LLC has the authority to bind the LLC to the loan documents. And in this case, what a title company would do is it would look at the operating agreement to see who has the power to sign any loan documents. What's in this case, in a member managed LLC, the operating agreement said that the individual members had the power to do so. Now, the question you have as far as whether or not this was for the benefit of the LLC, that's between the members themselves. If for some reason Jay Greenwald was not acting within his powers, then Loan Buddies has a cause of action against him. That is that's an intercompany issue. That doesn't have anything to do with what a lender needs to look at. It's not a lender's obligation. There's nothing under Ohio law or any law that I'm aware of that says the lender needs to see how the funds are being used to determine if the person that's signing the loan has the authority to do so. In this case, the operating agreement, something to keep in mind too, is that, whether or not it was within the ordinary course of business, you kind of need to look at what the business was. And in this case, this was a holding company for different assets, Ohio assets. There were 19 different assets. This was a loan on just one of those assets. And it was a $90,000 loan, which is a lot of money, but not, compared to what was the rest of the assets in there. And
were all the assets real property?
No. Some of them were lease agreements. Some of them were notes and mortgages. It was a collection of different distressed assets. What the court did is, in looking at basically saying that that Mr. Greenwald didn't have the authority, it looked at Ohio and Idaho LLC statutes that basically say that any action that is not in the ordinary course of business needs to be approved by the members by majority vote. But the problem with it in the cases that were cited by the court, those are basically default provisions. If an LLC wants to give a managing member the authority to sign loan documents and to have the documentation that says that, it can put that in the operating agreement, and it does. If the LLC, however, wanted to make sure that all loan documents were approved by both, it could have said so in the operating agreement, and it did not. There was also a provision in the operating agreement that allowed self-dealing by the different members because they had multiple LLCs. This was not just one. So I think that the trial court's reliance on the statutes that he cited just was simply incorrect. The conclusion, in addition, the conclusion that only one member needed to sign the Levrese note and mortgage is also expressly stated in Ohio's limited liability company statute, which is RC 1705.35. And that's entitled—
Counsel, did you raise that issue, that argument before the trial court?
Yes.
Where?
During our arguments.
The oral argument?
Yes.
Okay.
And I believe it was in our post-trial brief also.
Okay.
And in that statute, which it states, and this relates to member-managed LLCs, it's entitled Execution of Instruments and Documents of Conveyance. And it states that instruments providing for the mortgage of property of a limited liability company are binding on the company if executed by one or more members of the company. And this course of action is also fully consistent with Ohio Bar Title Standards 3.5, and that's entitled Conveyances, Partnerships, and Limited Liability Companies. And that provides that when it does not appear that all members are executing the conveyance, satisfactory evidence of authority, such as the current operating agreement, resolution, or affidavit, should be obtained. The trial court, however, incorrectly found that a resolution was required even if the current operating agreement provided satisfactory evidence of authority. Basically, the trial court inserted the word "and" instead of "or" in that bar title standard.
And counsel, you are at your time if you'd select to reserve 3 minutes.
Yes, Your Honor, I would.
Okay, thank you. Mr. Matre, you have 15 minutes.
Thank you, Your Honor. I would start out by saying that this case is a poster child for why you need a lawyer when you do a business transaction. My perspective on—
Well, when you don't, you end up in front of us, right?
That is correct, and that's not a good result. My perspective is completely opposite than appellants, and I've tried to look at this thing as to substance over form. And I tried to look at it, what were the parties trying to do and how did it work out? Now, this all started when Greenwald and Perrone came to Gary Clark and Loan Buddies, said, we want to buy a portfolio of loans and properties down in the Cincinnati area. And initially asked for a loan. There was no loan ever given to them. The deal was that Freedom Fund would acquire, which the original members of Freedom Fund, although there are 4 different LLC operating agreements, at least all concur that they were Perrone and Greenwald. There were some others that just never seemed to be anything of substance in the trial. They filed the original operating agreement, and the deal that was presented to my clients, the new Freedom Fund, was that Freedom Fund will buy these assets using money that Loan Buddies gives them, and that they, Greenwald and Perrone, will convey their interest in Freedom Fund to Loan Buddies. And
well, wait, so are you taking the position that Greenwald was not a member of the LLC at the time these transactions occurred?
I'm going to, well, my position is that what they represented, Greenwald represented to Gary Clark, was that that Loan Buddies was the sole member of Freedom Fund. Now, obviously, the documentation doesn't follow that. I'm just saying that this is what everybody thought when they did the deal. And that the job of Greenwald and Perrone was to be property managers to manage the assets to enhance their value, because there was an option to purchase them back at a set price. Now, again, the documents don't mention Greenwald. It just mentions Perrone. So again, we've got.
Also, you're saying it's not a loan. And I reading the documents, that just does not bear that out at all. It says it's collateral for the aforementioned loan. It says Buddies concurrently lent to transferee funds. So how can, I'm really struggling with how it cannot be a loan.
Well, that was, everybody in the case struggled on that, Your Honor. And we'll get back to it, that it is I would say a bit of a weird loan agreement. It's more like a pawn. They put up the property and gave the title to the Loan Buddies. Now, again, their documentation is terrible, but the documentation, according to Gary Clark, was all presented to them by Greenwald and Perrone, and that they were the ones that put it together. And it was allegedly based upon a prior deal that these parties had done earlier, several years earlier. So that was how they came out. So the idea was that Greenwald and Perrone were to enhance the value of the assets, purchase them back under the option agreement, and the other thing was they had no obligation to purchase them back. It was clearly an option. So when it came time for this loan, we don't have a whole lot of information other than apparently Greenwald and Perrone went to Levrese and said, we want to borrow $90,000. Now, the point of this is that lenders and the judge with 27 years of business cases on the bench knows that no lender will make a loan, especially of $90,000, without knowing where the proceeds are going. And I think that's part of the conclusion, or that's how the judge came to the conclusion that Levrese knew what was going on. I don't think it quite gets to that, but it is clear that Levrese knew that the money was going from, the loan was to Freedom Fund, and the proceeds were going to Vendi Inc., owned by Perrone and Greenwald. Now, in that loan transaction, the title agent, in his title commitment, required a resolution signed by all members attesting to the authority of the deal. Perrone didn't sign it. There was no resolution of all the members, and I suspect that the reason Perrone didn't sign it is because he had pains of conscience.
Let me focus you on what the trial court said, because the trial court, in analyzing Greenwald's actual authority, was focusing on the statutes both in Idaho and Ohio. And to me, that kind of flips the analysis, because I understand those statutes to supply default rules that can be overridden by the individual operating agreement. So why, was the court wrong in looking at those statutes rather than the operating agreement?
Well, I don't think the court was wrong in the sense that Ohio statute, the Idaho statute, both require that any action of a LLC that is outside of the ordinary course of business, it must be approved by the majority of the members. And again, we've got this whole mess of paperwork. There was paperwork filed shortly. Okay, the original foreign LLC was filed by Perone and Greenwald shortly after this deal took place. Shortly after that, Julie Myers filed another document that basically said Perone and Greenwald were no longer members or managers. They had no longer had any authority. When questioned about this to the title agent said, well, I disagree that that's what it says. And the judge was a little bit
well, I mean, whatever the title agent says doesn't really matter because the title agent could be wrong. They're trying to give, you know, the parties comfort, but they're not the decision makers here. And I guess going back to the language of the operating agreement, it seems to provide pretty broad authority to the members to conduct business on behalf of Freedom Fund. So I guess I'm struggling with the trial court's conclusion this was outside the ordinary course, which I have trouble reconciling with what's in the operating agreement.
I won't disagree with you. I mean, all of those documents spell out things that I don't think any of them ever looked at, quite frankly, because again, the deal was that this was Freedom Fund was now a sole member of Loan Buddies. Greenwald initially reported back to Gary Clark as to what was going on. But then about the time of the loan, stopped reporting what was going on. Again, my position is this whole thing was just out of the ordinary course of business. This was two guys that figured out that they could get away with something and did it.
But then isn't the remedy, as was suggested in the earlier argument, isn't the remedy between Freedom Fund and Mr. Greenwald saying like, hey, you exceeded the bounds of your authority, you defrauded us, we want to recover from you, rather than how the trial court sorted it out?
Well, that would have been one of the remedies. I think that the remedy chosen by Freedom Fund was to get that mortgage declared void. A lot of this stuff didn't even come out until trial, quite frankly.
Well, I mean, I guess from just an equitable standpoint, why should Levrese be stuck holding the bag here when Freedom Fund, with it's one of its members, signed all the paperwork on this deal?
I hate to say this as a title agent, but they had title insurance, and that's what this is about. Question is the title insurance company going to pay, or is it going to be foreclosed? That's the reality of this case. Again, my perspective is purely substance over form. The documentation is all over the place. Nobody, I don't think any one of them understood it, at least by the documents, understood the documents. They just believed they were doing what they thought about, that was transferring the ownership of the Freedom Fund to Loan Buddies, and then they had the option to buy it back. At some point, they decided to take advantage of that, whether or not they went and looked in the documents and made the same conclusions that the appellant is making. We have no evidence. Mr. Greenwald was served by the appellant, and it was never, let's see, they tried to serve him. I don't know if they ever got service let him or not. He's still out in Idaho, as far as we know.
Counsel, your opposing counsel brought up RC 170535 in the brief. Does that apply to this case?
Pardon me?
1705.35 which says that instruments and documents providing for the acquisition, mortgage, or disposition of a property of an LLC are valid and binding upon the company if the instruments or documents are executed by one or more members of the company. Does that apply here?
That applies, but then again, there's the other part that about ordinary course of business requiring the consent of the majority of the members. So you've got two competing decisions. One is which one really controls in this situation where you do not have the consent of all the members. The judge clearly decided this was outside of the ordinary course of business because it did not enhance the value to Freedom Fund in any way, shape, or form. It only enhanced Greenwald and Perone. Yes.
I was going to say you've got 2 minutes left if you have anything further.
Well, I think I've said what I wanted to say. The only thing is that I think there's been some confusion about what a finding that the judge made that Levrese knew that Greenwald was acting for his own benefit. I don't think that's what the judge meant. I think the judge meant that the lender knew where the loan proceeds were going, not necessarily that it was out of the ordinary course of business or anything like that. We have no evidence or testimony as to collusion. I suspect Mr. Greenwald and Mr. Perone may not have been totally upfront in their loan application, but we don't know that. And with that, I'll rest.
Okay. Thank you very much. Ms. McNamee, you have 3 minutes for rebuttal.
Thank you, Your Honor. The first thing I would like to address is the issue of the ordinary course of business. And that provision, that statute applies when you don't have an operating agreement. That is a default provision, and it can be altered by the terms of the operating agreement. So individuals can sign documents that are outside of the ordinary course of business if the operating agreement says that it can. The second issue I wanted to address was this is bigger. This appeal is bigger than this case. The trial court essentially has added an additional level of approval that just is not that's against bar title standards. And so to say that if an operating agreement gives permission or authority to a manager to sign loan documents,
Is there any ordinary course carve out in the operating agreement?
Not specifically, no, but by saying that they have the authority to sign a loan document or sign anything and make representations to financial institutions as to their individual authority, that covers, that trumps whether or not this is a loan is in the ordinary course of business. The other issue is—
Wait. Let me back you up for just a second. But it also says for specific business, but that's not really defined. The only specific business was defined is outside the scope of this case.
I guess I would interpret for specific business, it would be for specific business purposes. It is not very clear. I mean, not as clear as I would like it to be, but it does say that the members have the individual authority to act on behalf of the LLC. The good faith in this case is not where the funds were going or whether they were going back to Freedom Fund. The good faith is, did Levrese and the title company act in good faith and believing that Mr. Greenwald had the individual authority to bind the LLC? And the operating agreement, we believe, states that they do, and they didn't have to go further than that. Taking $90,000 out of a company or stripping equity from the company, that's not inherently wrong. Lenders don't ask, what are you using the funds for? It's really none of the lender's business. And so if you look at the operating agreement gives the individual the authority to sign. That's where the good faith ends. I guess that's all I have. Thank you.
You're right at your time. So perfect timing.
All right.
Thank you both for your arguments today. Very, very interesting case. We'll take the matter under submission and get out a timely written opinion, and hope you both have a great day.
Thank you.
Thank you, Your Honor.
Bye.
I'll go ahead and pause the